In episode 27 of the DUI Lawyers Court Reports show, we take a look at a low-range drink driving offence of .057 where we achieved a Section 10 dismissal of the matter.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. They say it ain't no way. I ain't never listened, kept them at a distance. This is for the ones who ain't afraid. And this is more than some paper chase. I wonder who else can say the same.
G'day, welcome to DUI Lawyers. It's Josh Bondman here. I'm just standing out the front of, or out to the side of the Downing Centre local courthouse in the middle of the CBD in Sydney. I've just appeared on a low-range PCA or drink driving matter, which actually occurred out in the regional area of Mudgee in New South Wales. However, our client was out that way travelling in regional New South Wales for work purposes. He was pulled over at about 9 a.m. in the morning. He was pulled over because he was detected to be speeding over the assigned speed limit of 100 kilometres an hour. He was actually driving at about 115 kilometres an hour, making the mistake thinking it was 110 kilometre zone. So that's what brought him to the attention of police. It was about 9 a.m. In the morning. He had had some drinks the night before, and unfortunately he recorded a blood alcohol reading in the very low end of the lower range category at .057. So he was obviously charged with low range PCA. We actually got the matter adjourned and transferred from Mudgee local court a number of weeks ago. We had it transferred closer to where our client lives here in Sydney at the Downing Centre, and it was in for sentence today. And we appeared. We presented some very strong oral submissions on behalf of our client, basically trying to talk about the relatively low level of objective seriousness of the offence, given it was a low level reading. There was obviously the issue of the speeding, which brought him to the attention of police, but he was the only person in the car. The speeding occurred on a wide open regional road with not many other, or barely any other traffic around. So whilst the speeding was aggravated, it was sort of watered down a little bit. But the big issue is that for the magistrate to have regard to was the low level of blood alcohol concentration of .057. We did submit to the court that it was a next day type of offence, so he hadn't spilled out of a nightclub, he'd had some drinks the night before, he'd gone to sleep and still had a presence of alcohol in his system. The magistrate did make a point of saying that Parliament, in their drafting of the legislation, does not make a difference between whether someone has spilled out of a nightclub or whether it's a next day offence. When the blood alcohol limit says that a person is over the .05 threshold, then it is just as dangerous regardless of the circumstances which led to the offence. So I guess the only retort or submission we had to make in that regard is that whilst the blood alcohol reading was over the limit, our client's frame of mind that morning was more of the belief that he was under the limit, as opposed to if he had of just prior to the driving had a few drinks or spilled out of a hotel or nightclub. So it could have been far more believable to the court to see that our client was under the impression that he was under the legal limit. So that's a big issue that does come up with a lot of next day offences, which are becoming more prevalent since the police are setting up a lot of RBTs and catching people out the next day after having a few drinks the night before. So that being said, we in relation to preparation for the case, as usual, we got our client to go along and do a traffic offender program where he learned a lot about driver safety, how alcohol affects the body, in particular how it can actually take up to, in some circumstances, 24 hours for alcohol to be removed from a person's system. So he came away from completing that course far better educated. He had a workbook to hand up, which was completely filled out. He had a completion certificate. We got a strong letter of support from our client's employer, indicating to the court that his driver's licence is a minimum requirement for his job. So, in other words, if he was to lose his licence, he would lose his job. And that was a big issue that the court had regard to in deciding how to deal with his matter. We also got a reference from his partner and also a letter of apology from our client to the court outlining significant concerns about losing a licence, what went wrong on the night, and other issues regarding our client's good character. One other issue was made of our client's traffic record. Now, he had only been driving in New South Wales since 2015. I did indicate to the court that he had driven in Victoria for 3 years prior to that, so from 2012 to 2015. I mentioned to the court that it was my instructions that our client had no other entries on his Victorian record. And what the magistrate did was, on the spot, he decided to stand the matter in the list, and so that the prosecution could go and obtain a Victorian driving record, just to confirm that there was nothing there on his record. Now, thankfully, my client was truthful in his instructions to me. We got a copy of the Victorian traffic record. There was no entries on that record. So that being said, he's driven in New South Wales and Victoria in Australia, because he's originally from overseas, for a period of a bit over 5 years, and this was the first entry on his record in that time. For this incident, he had a completely unblemished record, so that certainly weighed in his favour as well. Ultimately, our client was lucky enough to be granted the leniency from the court by dealing with his matter by way of a Section 10, putting him on a good behaviour bond for 12 months, which ultimately means that his licence was not disqualified, a criminal conviction was not recorded, he didn't receive a fine, but he must be of good behaviour for the next 12 months. If he does break that bond, then he can be brought before the court and resentenced on the fresh charges, as well as this particular offence which was before the court today. So, in effect, our client has been able to save his licence, continue driving, which will mean that he can continue in his current employment, which is certainly a plus. He's come away from this course having learned a lot about driver safety and how alcohol can remain in the system, even a number of hours after consuming drinks. So, a very happy client today, and we're happy to be able to represent him and get a good outcome from him at the Sydney Downing Centre local court today. So, I mean, drink driving, especially low range and mid range, it is quite a prevalent offence within our society. If you found yourself making a mistake or falling foul of the law, where you have been charged with a drink driving offence, or even a drug driving offence, or any sort of major traffic offence, well, that's what we specialise in. You can contact me on 1300 941 900. I'm happy to have a free first telephone consult about you and your situation you might find yourself in. Alternatively, go along to our website, which is boormanlawyers.com.au. That's BOORMAN lawyers.com.au. There's heaps of information there on laws, offences, penalties. There's blog posts, there's statistics, there's case studies, videos like this one, which you can find there on our website. You might want to read up and make yourself a bit more familiar with the situation that you might find yourself in. But of course, if you want to give me a call to chat more about your case, 1300 941 900, and certainly also happy with to discuss how we can best represent you when your matter comes before court. Thanks for tuning in today, guys.
Thank you.